Good evening, everyone. Thank you for joining this webinar tonight about physician immigration. I just wanted to give people a couple minutes time to log on and get settled in. But in the meantime, I will start off by saying that this webinar will be recorded and you can go back and watch it after it's said and done, and it'll be posted on our website. If you have any questions between this webinar, go ahead and put those in the Q&A or the chat box, and we will answer those along the road. And then there also will be a time for Q&A afterwards as well. For those of you who don't know me, my name is Peyton Jennings, and I am the Physician Engagement Coordinator here at Practice Match. I work very closely with the residents and fellows that participate in the virtual career fairs and the promoter program. And if you're here tonight, you probably already know a little bit about Practice Match and like what we have to offer. We had a virtual career fair tonight. We have one almost every Tuesday, and during those fairs we offer a physician immigration handbook that is here because of Siskind. And then we also have a physician career guidebook. We have free CV reviews, and we also offer a residency physician scholarship every year. So now that looks like we have a little bit of an audience, Elissa, you can go ahead and start whenever you're ready.
Great. Thanks so much, Peyton. I'll start off by introducing myself and giving a little overview of what we'll talk about tonight. That way, if any other folks join us a little late, they won't miss too much. My name is Elissa Taub. I am a partner at the law firm Siskind. We are a boutique immigration law firm, which means that we only handle U.S. bound immigration matters. We don't work on any other kinds of legal matters. I am the head of our firm's healthcare immigration practice, and I work primarily with physicians and also with other healthcare professionals with regard to their immigration needs. I'm the co-author of the Physician Immigration Handbook that Peyton mentioned, and I'm really excited to be with you. I want a couple of things. My Wi-Fi is a little glitchy tonight, so if I do freeze or if my words are a little bit muffled, I apologize. I'm not really sure what the technical issue is on my end, but we'll do our best to keep things moving. In addition, if you have questions, please feel free to put them in the chat or the Q&A as we go. I'll monitor the questions along the way. That way I can make sure that I'm answering them at the time that's most relevant. And the last thing is, even though I'm a lawyer, I may not be your lawyer, and this is definitely not a confidential setting. So it's hard for me to give individual immigration advice in this environment. I'm happy to answer general questions, but at the end of the webinar, I'll share my contact information, and you're always welcome to schedule a consultation with me or with any of our immigration attorneys. So with that, let's get started. Tonight, we are just going to do a very basic introduction of physician immigration, primarily J1 waivers and H1Bs. Those are the two most common statuses that we talk about with doctors. And so we're going to first start off with a general discussion of J1s and J1 waivers, and then we'll move on to a discussion of the important key items to know about H1B sponsorship. We'll start off very basic. As I mentioned, most physicians who come to the United States to practice need to initially start off by participating in a residency program. And then if you want to specialize, you may continue on to do a fellowship. Physicians who come to the U.S., most of you who are on this webinar probably are already here in the United States, and you're on an H-1B or you're on a J-1 already. And you'll know that that decision, whether to go on the J or the H, largely is dictated by your residency program. But the results of that decision are really, really important for the immigration journey that you will take through your time in the United States. For J1s, the most important thing to know is that all J1 physicians who come to the U.S. for a residency or fellowship are subject to something called the 2-year home residence requirement, and we're going to talk a lot about that tonight. And for H-1Bs, the most important thing to understand is about H-1B Cap Exemption. Most doctors who come to the U.S. for training on H-1Bs do so on Cap Exempt H-1Bs. And that is important for when you move on to your first post-training job. So we'll talk about that later in the program. And then also there are certain time limits wrapped up on H-1Bs, namely the requirement that you can spend a maximum of 6 years in the status unless you apply for a green card and start going through some of that. So we'll talk about those issues as well as we go through. So this just helps us set the stage for what's to come. So we'll start off with the J. And the reason why I start off with the J is because the vast majority of physicians who are in the United States training are in J1 status. I think now the number, it's somewhere over 80% of physicians who initially match with residency slots are coming on J1s. The J1 home residence requirement is really important to understand. A lot of physicians know that there's something that applies to them. They know they need a waiver. They don't really know what they're waiving or what the upshot is of being subject to the home residence requirement. So as you'll see on the screen, a person who is subject to the J1 home residence requirement must return to their home country for 2 years or obtain a waiver of the requirement. And if they don't, they're unable to change non-immigrant status in the US, meaning you can't change from J1 to anything else. You can obtain an H-1B visa abroad. So, okay, you can't change in the US, but you're like, okay, well, I'll go visa stamp, but you can't because you can't get the H-1B visa. And you're also ineligible for a green card. It actually is a ground of inadmissibility for green card purposes to be subject to the home residence requirement and either not have fulfilled it or gotten it waived. The only two options really are fulfillment of the home residence requirement and getting some sort of waiver. The passage of time doesn't make it go away. Marriage to a US citizen doesn't make it go away. You either are planning to return to your home country or country of nationality or a country of last permanent residence before you came to the US, or you're getting a waiver. When we talk about, country of nationality or country of last permanent residence, the easiest way to figure out what your country of return is to look on your DS 2019 and see what the country is that's listed there. Sometimes that's not the end of the story, but that's typically where the US government is expecting you to return. Tonight, we're not going to talk too much about fulfilling the home residence requirement, but there are some things to know. It is an option. And I do talk with physicians all the time who did return home for 2 years and now are looking to come back to the United States. Basically, when you do that, you're just like anybody else who's seeking work in the US. So all the typical H-1B rules or green card rules or whatever would apply to you. There's really nothing special about having fulfilled the requirement other than you need to make sure you have documentation of the fact that you spent 2 years in your home country, in that country of return. Importantly, like if you're from Europe, going to any EU country is not a substitute for going to your home country. So if you're from the Netherlands, you have to spend those 2 years in the Netherlands, not in Germany, right? You can't do it by proxy or in a different country. The other thing to know is if you are a J1 and your spouse is on a J2 and you go home and fulfill the home residence requirement and your spouse on the J2 wants to stay here, you can't fulfill the requirement for your spouse. You can get a waiver that covers your spouse, but the J1 and the J2 are both subject to the home residence requirement and both would be required to return to the home country to fulfill it. In other words, the J1 can't do that on behalf of the J2 and vice versa, to be honest, right? Each person is subject on their own. So that's a little bit about fulfilling 212E. 212E is the section of the Immigration and Nationality Act that actually created the home residence requirement. So if you see reference to 212E, it's the same thing. But let's talk a lot about waivers. Most of the physicians that I talk with are interested in getting this requirement waived so that they do not have to go home for 2 years. The most common waivers that I work with and the most common waivers that physicians seek are those based on working in an underserved area for 3 years. And that's a full-time work commitment. That's the essential basic requirement of the waiver. There are two ways to get this waived through working in an underserved area. One is to apply through a Conrad 30 or State 30 program. That's where each state gets to support up to 30 doctors in a federal fiscal year for waivers. The 30 is a hard max. They can't go beyond that. And the other way is to go through an interested government agency or IGA. These are agencies of the United States federal government that can issue unlimited waivers. I've listed them on the screen for you. Notably, that first bullet, the DRA, the ARC, and the SCRC are regional commissions. They cover certain areas, certain regional areas of the United States. The DRA covers 7 states, 250 counties in the middle south of the United States, from parts of Missouri and Illinois, Western Kentucky, Eastern Arkansas, Western Tennessee, Western Mississippi, almost all of Louisiana, and a little bit of Alabama. The ARC covers a huge swath of the Eastern United States, from Mississippi all the way up into New York, all the way through that Appalachian mountain range. And the SCRC, the Southeast Crescent Regional Commission, is a brand new federal agency that brought online a waiver program this summer that covers all parts of Virginia, North and South Carolina, Georgia, Alabama, and Mississippi, and all of the state of Florida. So there are a lot of areas in the Eastern United States that now have unlimited waiver access. Pretty much almost the entire states of Virginia, the Carolinas, Georgia, Alabama, and Mississippi, and now all of Florida. There are pretty much unlimited waivers available all through that region now, and then on over into some of the middle South states through the DRA. So it's very exciting that the SCRC came online this summer. Our office already is preparing. I think maybe has filed one, and we have 4 or 5 already going in our office for this fall. It's really a game changer in terms of waiver availability. HHS, which is listed there, they have a waiver program for clinical physicians that is limited just to primary care. I should mention the DRA, ARC, and SCRC all support both primary care and specialist physicians in underserved areas. HHS will only cover primary care and hospital medicine physicians who are going to start work within a year of completing residency. It essentially means they are not looking for fellowship trained physicians. At max, maybe a 1-year fellowship, but there are some special rules that apply to those. In addition, the location can only be in an underserved area called a health professional shortage area, or HPSA, that has a score of 7 or higher. So it's a national program, HHS, but it's limited in application to the categories I just mentioned. And then also the VA, the Veterans Affairs Administration, has its own waiver program that they pretty much administer in-house. So if you look at a position with the VA, that's something that largely would be handled by their HR department. Okay, so those are the 2 ways to get underserved area waivers, the State 30 programs and the federal agencies. In addition to underserved area waivers, though, there are other kinds of J1 waivers. There are research waivers through HHS. I won't spend a lot of time on these, unfortunately, for a lot of reasons I won't bore you with. These waivers are taking up to fees the government to go through. So for that reason, a lot of folks choose not to pursue them. But if you're in an academic position that is heavily focused on research, or if that's a career path that you're looking at, sometimes a physician will choose to seek an O1 visa or O1 status post-training. The O1 is available to somebody who has extraordinary ability in their field, and the 2-year home residence requirement doesn't bar somebody from obtaining an O1 visa stamp and returning to the US in O status. So sometimes somebody who's going into a really research-oriented, research-focused position will go into O status. And then years down the road, after they've really made a name for themselves and have kind of climbed the ladder a little bit, and have, are really driving research at their institution, they may be sponsored for an HHS research waiver. They are held to a very high standard. They're really looking to make sure that you are essential to the research that's going on, and they're sponsoring academic institutions really has a long-term plan for you to stay. And typically they have to be supported by an academic institution. So I won't, like I said, I won't spend a lot of time on those tonight. It's a very different kind of waiver than the other ones we'll talk about. There are hardship waivers. If you are married to a U.S. citizen or green card holding spouse, or you have a U.S. citizen or green card holding child, you may be eligible to apply for a hardship waiver if you can show that complying with the home residence requirement will cause exceptional hardship to that qualifying relative. It's not about your hardship, it's about their hardship. And you have to show that that hardship would exist whether your family member returns with you to your home country or whether you're separated. That hardship has to be more than what a typical family would experience from the separation. So we typically look at medical, financial, educational, career hardship, cultural barrier, all those kinds of things go into a hardship waiver. Persecution waiver is available. You do not need a qualifying relative, but here what you're talking about is showing that you would be persecuted upon return to your home country because of your race, religion, or political opinion. It sounds a lot like an asylum claim, and it is similar, but it's a J1 waiver, right? It doesn't grant you asylum. It just grants you a waiver from the J1 requirement, but it can be a really helpful tool to seek a waiver. Whoops. And let's see. So, there are some very important differences between the hardship waivers or persecution waivers and the shortage area waivers. And I've put some of the most important differences on this slide. And so one of the most important things that folks don't really realize about hardship waivers, in fact, I talked with a doctor today who we were talking about an underserved area waiver through the ARC, and they said, well, what about a hardship waiver? And we talked about some of these things during the meeting. One thing is that if you receive a shortage area waiver, and we'll talk about this, kind of the way that those work a little bit later in the presentation, but you get a lifetime exemption from the H-1B cap. And that can be really key, especially if you're from India or China and you're going to face the lengthy green card backlog. And you're thinking, well, I'm going to get my initial waiver through this one employer, but I might want to change employers down the road. It doesn't matter if your employer is nonprofit, if they're academically affiliated, none of that matters because you personally are exempt from the H-1B cap. And so that's a really huge, bonus for future mobility purposes. For hardship and persecution waivers, you're treated pretty much like any other applicant. So you do not get that automatic cap exemption. So if you're not married to a US citizen, or if you don't have a ready way to get, if you're not maybe of the caliber, you're not really eligible for an sponsorship, then, if you're thinking, well, I'm going to get my hardship waiver and then I'll just change H-1B, you really need to look at what employer you're going to or what the work site you're going to will be, and if they can support that cap exempt H-1B for you. So it may limit your job search in that way, even though you might not be looking at an underserved area, you may need to be looking at an academically affiliated employer instead. With shortage area waivers, you can make that change from J1 to H-1B right from here in the United States without taking a trip. The same is not true for hardship and persecution cases. In those cases, you must take a trip abroad and obtain a visa stamp in whatever relevant category in order to come back to start work. The one exception there is that because hardship and persecution waivers do not require a 3-year commitment, you can immediately be sponsored for a green card. So if you're married to a US citizen spouse and your hardship or waiver or whatever it is approved early enough, they can file a green card application for you and you may be able to avoid leaving the United States that way. But if you're not married to a US citizen or permanent resident spouse and your hardship waiver is based on a child, or if you're filing a persecution waiver because you don't have a qualifying relative, then the need to visa stamp is something that you need to take into consideration, understanding that that's probably going to affect your planned start date and you're going to need to build in that time. Especially in some parts of the world, like in India right now, where it can be really challenging to schedule visa appointments. So it's really important to know that. As I mentioned, with shortage area waivers, you have to complete that 3 years of service before finishing your green card application. And there are no exceptions to that. That calculation, I get that question a lot. But with hardship and persecution waivers, you can go straight to green card sponsorship without any further delay. The final thing is that for a shortage area waiver, you have to have a signed employment agreement for that waiver position before you file for the waiver. You can't apply for the waiver in like Tennessee and say, well, that's where I want to work for 3 years. I'll find the job once I get the waiver. I'm making the commitment to work for 3 years. That's not the way it works. That employer is going to sponsor you for the waiver. And so you need to have the job already lined up and the contract signed. Now, what happens if you apply for the waiver and it's not approved, right? You apply in a state like Texas, where they got 36 applications for their 30 slots this year, and you were one of the 6. Well, the contract is void, right? You can't perform on it because you're not able to get a visa to perform on it, right? You can't get the right immigration status to authorize you to work for that employer. So the contract can go away, but you have to sign it on the front end. On the hardship or persecution waiver side, no employment agreement is needed, right? That's a personal application. Your employer is not going to really be involved in that application at all. So it's just some really important comparisons between or contrast really between the shortage area waivers and the hardship and persecution waivers. Let's see. All right. So I want to do a little bit deeper dive on the shortage area waivers because there are a lot of details on these, a lot of weeds. And I think it's important for physicians as, you know, you may be a 2023 or 2024 candidate who is just starting out on a job search, or maybe is in the throes of a job search, or you might be going through the waiver process right now and you feel a little bit like you're on a wire without a net, right? It's a little topsy-turvy and stressful. And so I think getting into some of the specifics is important. So we'll quickly go through some of the basics. We already talked about the fact that the shortage area waiver requires a 3-year full-time commitment to work in an underserved area. How do you find an underserved area and what are you looking for? That link right there, data.hrsa.gov/tools/shortage-area, that is your best friend when it comes to looking for underserved areas. You can go to that site and type in pretty much any address in America, and it will tell you if it's located in an underserved area. The types of underserved area that you're typically looking for are primary care HPSAs or MUAs, and sometimes MUP. It'll say on there MUA/P, that stands for medically underserved area or medically underserved population. Even if you're a specialist, the type of underserved area that you're looking for is still primary care HPSA or MUA/P. The reason why it says primary care HPSA is that the calculation is based on a ratio of primary care health providers to population. And so that they don't take specialists into account in the calculation, but it's still applicable. That's what all of the waiver programs look for. The type of underserved area that a particular program might accept might vary. So not every program accepts all of these designations. I already mentioned one. HHS is only looking for primary care HPSAs with a score of 7 or higher. But this is a really important tool. You also can go and look by state and county, but if the entire county isn't designated, you're basically going to end up with a list of census tracts and have to go find them on a map. So I find that the address tool is a little bit more helpful. Every state has the opportunity or option to use 10 of its 30 waivers for something called flex. Some people think flex refers to specialists, but that's not what it is. A flex waiver is for a doctor who will not work in an underserved location, but where there's a showing that patients from underserved areas or with certain underserved characteristics, like high Medicaid percentage, are being seen at the facility. Some states do not use these, but many of them do, and every state that uses them has different criteria for what qualifies. But importantly, the federal agencies I mentioned, DRA, ARC, SCRC should be listed there as well, and HHS, the law does not allow them to do flex waivers. So to do a federal agency waiver, you must be working full-time in an underserved location. The other basic is that the full-time for this purpose means 40 hours a week or 160 hours a month. That is your basic commitment for patient care. Doesn't include call or travel time, typically doesn't include research or teaching time as well. I know sometimes I know emergency medicine physicians always freak out about the 160. Patient charting, patient transitioning, anything that is directly related to the care of a patient can count in that 160 hours per month. It doesn't have to be 160 hours per month face-to-face with a patient. But this is, what the government is going to expect, and that commitment 40 hours per week or 160 per month has to be in your contract. So it's going to say that. And there's not really any wiggle room on that from the government's perspective. The other thing is every contract has to have an agreement in it that you will start work within 90 days of when USCIS approves your waiver. People get very nervous about this. It is not that you are saying that the law does not say absolutely that you have to start work within 90 days of when your waiver is approved. The law says you have to agree. That word agree is really important. You must agree to start work within 90 days of waiver approval, and you will make that agreement in your employment contract. The real purpose of this provision is to ensure that physicians are applying for these waivers in the fiscal year in which they will finish their training, not 2 or 3 years ahead of time. The government wants to know that if they are granting you one of these coveted waivers, that you are going to be working in a place where they have a need for you, and you're going to be doing it soon. And that's the rationale, the thinking behind this 90-day requirement, but it's not a firm, hard 90 days from when the waiver. I have clients that already, theoretically have waivers approved or will have waivers approved by December. They can't possibly start work within 90 days of December. So just to give you an idea, that's just not legal or practical. So it's really just an agreement. So those are the basics, right? These are the things that are the same no matter what. Every state, 3 years, full-time underserved area, full-time definition, agreement to start work within 90 days. And from there, all bets are off. Everything is different. Every state, every federal program, they all have their own rules for how they are going to allocate their waivers. So if your friend applies for a waiver in New York and their filing deadline is December 3rd this year, and they don't find out about the waiver success until March or April, and you're applying in Tennessee where you can pretty much apply anytime, right? Your experiences and what's required for your program are going to be completely different from each other. What differs? Everything. How they treat primary care versus specialist physicians. What documentation and evidence is needed to justify the waiver for primary care versus specialists. Are hospitalists considered specialists or primary care doctors? That's even a variation. How do they prioritize primary care over specialists, or do they pretty much treat everybody the same? Those things may vary from program to program. When you have to file, some states already have filing deadlines that are in the past. Kentucky, Illinois, Missouri, Michigan, or Missouri. Those filing deadlines are in the past. They were October 31st, and those close you can now. Other states, like I mentioned, Tennessee, well, you can apply there right now. They're not full. Mississippi, Utah, Nevada, lots of states don't have filing deadlines. Recruitment. Every waiver program is going to require your employer to include evidence that they tried to recruit non-J1 physicians for their position. But the type of evidence that has to be submitted, whether it's just a description and a cover letter, or whether it's actually providing copies of the ads, or whether the ads had to have been run in a specific period of time and in a specific place, all of that will differ. Now, that's not evidence that you are going to be required to submit as a physician, but it's important to know that your employer may or may not have a decent amount of legwork to do, a decent amount of work to do behind the scenes to get all the documentation together for the waiver. Sometimes we have to have employers run recruitment specifically to satisfy the waiver rules before we can file the application, which can delay a filing. Most states, most federal programs require some submission of payer mix data. They want to know, what kind of patients are being seen at this practice. Sure, you're in an underserved area, but do you really see and treat patients without regard to their ability to pay? Do they have a sliding fee scale or charity care policy for patients that can't afford to pay for their care and might be uninsured or who might be underinsured? And finally, the employment agreement terms that you will be subject to also will vary. Some things that vary with employment agreements will be, there be termination without cause? In some states and federal programs, they don't care about that at all. And in other programs, they are very specific. Not only can't you have termination without cause, but you have to say termination without cause is not allowed in this contract. Most programs disallow non-competes or restrictive covenants, not all of them, but many of them. It's important that the locations where you're going to work be specified in a contract by name and address. Some states might allow you to have some underserved and some non-underserved locations as long as you are going to work full-time in the underserved locations. Other states like Arkansas say, you can only work in underserved locations to qualify for the waiver. Can you have locations in more than one state? For most Conrad 30 programs, that's a no-go, because why would Missouri want to recommend a waiver for you to work part of your time in Illinois? But if you're applying through a federal agency and all of your locations are within that agency's jurisdiction, work in more than one state might be okay. To give you an example, I'm based in Memphis, Tennessee, which is in the jurisdiction of the DRA, and plenty of physicians work both in Memphis and in North Mississippi. And DRA waivers, it's very common for doctors to go back and forth across the border or even into Arkansas. So, it may be possible to work in more than one state on a waiver, but it might depend on what type of waiver you're applying for and in which geographic area. How does your salary have to be represented in the contract? New Mexico and Virginia require that you have a guaranteed minimum annual salary. No hourly wages are allowed in those states for their waiver programs. Many other programs don't care as long as you're going to be earning at least the prevailing wage, which is a requirement for the H-1B anyway. Some programs allow liquidated damages, which is a set sum that you would the contract or make it early. Some programs require liquidated damages and some don't allow it at all. So you have the full gamut of policies on liquidated damages. And then I mentioned earlier that full-time is 40 hours a week or 160 hours per month. Ohio actually requires it to be represented as 2,080 hours per year. So even there can be a variation on something that basic. So we talked about what is a waiver, the different kinds of waivers that are available, what their requirements are, the variations in waivers, what might change, what might be different depending on the program that you're applying to. Let's talk about how they work. How do you apply for one of these waivers? You find, you go to one of Practice Match's amazing career fairs and you hit it off with a recruiter and you do a site visit and an interview and everything works out well. They offer you terms, you agree, and you go to sign a contract. What happens next for the waiver process? The first thing that's going to happen is your lawyer is going to, the immigration lawyer is going to work with you to file an application called a DS 3035. This is an application that is filed with the U.S. Department of State. Now you're thinking, if I'm applying for Conrad 30 or regardless of what I'm doing, why is the first thing I'm doing filing with the U.S. Department of State? The U.S. Department of State has co-jurisdiction. They share responsibility for the J-1 program with USCIS. And there is a lot about J-1s that is fully administered and governed by the Department of State. So it naturally follows that they get a say in who gets a waiver. And so every J-1 waiver, no matter the basis, hardship, persecution, shortage, whatever it is all going to make a stop at the Department of State. And so for that reason, the first thing we do is we get you a file number and we file a preliminary application with that agency using the DS 3035. That application is weird. We have to file it online and then we print it out and mail it in. So it's like 1990s technology, but it's a really important part of the process. So that'll be the first thing that happens in your case. That's not something that you need to file on your own. Like I said, the immigration lawyer that handles your file is going to work with you to get that done. The second step is that that lawyer is also going to work with you and your employer to prepare and file the actual waiver application with whichever state or federal agency you're approaching for that waiver. Typically, our physicians can get us all of their documentation within a few days. The type of documents that we're going to ask you for, your CV, your DS 2019s, your ECFMG certificate, USMLE score reports, your medical school diploma. We'll send you some things to sign. I mean, they're not complicated documents from your end, but from your employer's end, there's some more work that's got to be done. They have to put together a pretty detailed cover letter. There may be letters from community organizations that they have to source. They have to provide as evidence of the recruitment, all the payer mix data. There's a lot of coordination that goes on. So expect that it's going to take your employer a lot longer to get together their documents than it will take you, not because they're not paying attention, just because it's time consuming. Once that waiver application is filed with the relevant government agency, they're going to review it and they may ask questions after. They may come back and ask for clarification or changes to be made to the application. That's typically a good sign that they want to support the waiver, but they also want to make sure that the waiver application looks perfect if they ever get audited or somebody comes back and looks at the application. So once they're happy with it and they're ready to go, they're going to recommend the waiver and they're going to send it on to the U.S. Department of State, where it's going to match up with that file that was already open for you there. Department of State's going to review the waiver. They're going to recommend it and send it to USCIS. Steps 3, 4 usually just naturally happen. You don't have to take any steps to make it happen. Your immigration lawyer will let you know when those things happen. But once we get past that initial government agency, once we get past step 2 and into step 3, we feel like things are going to move in a good direction. We're not so worried anymore about success. It's just a matter of time. Once USCIS gets the application, they're going to issue a receipt and they're ultimately going to approve the waiver. That would be our expectation. And then when you get through all of that, that's when an application will be filed to change your immigration status from J to H so that you'll be ready to start work in H-1B status when the time comes. The H-1B is usually filed with premium processing and it's filed for a specific start date. So, if your H-1B is filed in March and it's approved in April, that doesn't mean you have to leave your residency early to start work or that you've changed to H then. Your H-1B status will become effective in the summer at the time, that you start work. So we see that Amy has asked a question: what is the time frame necessary to submit the J waiver? How far in advance? And that's a fantastic question. Most of the time we are looking, the best case scenario, let's talk about best case. Best case scenario is filing a waiver application in the fall of your final year of training. And I say in the fall, it could be anywhere from August to like December, depending on where you're applying, right? Georgia opens its program in August, you want to file in August. Texas is only open for the first 2 weeks of September, you want to file then. There are other states that have similar timeframes, but if you're going to be filing a waiver application in the fall of your final year of training, that means at some point before that, signing a contract. So potentially in the summer or the spring before your final year of training, like toward the end of that second to last year. You can expect that the process is going to take the better part of your last year of training, no matter when you apply. So even if you apply in October, depending on the state, you might not hear back from them until December. And then the case is first going to go to the Department of State. It could take a couple of months there, and then USCIS, and then the H-1B. And the next thing you know, it's May or June. That's not the only case scenario. There are times, for example, there will be 2023 candidates that I will file waivers for in April or May. I am not kidding. It happens every year. I have filed waivers all the way into June. Sometimes stuff happens. A waiver doesn't get approved that everybody thought it was going to be fine. An offer gets rescinded that you thought was solid. For your own personal reason, you decide to, make a change at the last minute before the waiver, is submitted or something. There are waivers available all through the year, through the federal agencies or through states that don't fill up. Just know that the later in the year that you file, February, March, April, July, August start dates become less likely the later in the academic year that you file, and your choices might narrow, of where you're going to be because of the availability or unavailability of waivers in certain places. Okay, let's see. So going on from there, I hope that answers, the time frame. It's hard to be super specific. One of my mantras, one of the things that I always tell physicians is that it is never too early to start looking for a job if you're on a J. I've been to career fairs in the past. I've talked with doctors who were PGY1 who just scheduled, consultations with me because they just wanted to know about the process so they could be prepared. And I think forming relationships with recruiters at facilities that you might be interested in working at down the road, figuring out, I want to be in this particular geographic area. Are there employers there that sponsor waivers? Getting to know them and reaching out and making contact there, that is never a bad thing. I also know that a lot of times physicians, especially in subspecialties that may be a little rarer, get very nervous about whether they'll even be able to find a waiver job. It may take a little more work to find those jobs, but they're there. We file so many waivers every year for all different kinds of physicians. I talked with a super subspecialized physician today, he was, a 2024 candidate even, who already is, involved in their job search. So it's never too early to get a jump on that. Now, sometimes you apply for a waiver, you find a job, everything's good, you start work, and then something bad happens and you're like, I need to change jobs. The government expects that when you start a waiver job, you're going to finish those 3 years, that you're going to finish that waiver the way that you set out on it. But if something happens and you need to change in the middle, there are 3 really important things to know. One is that you need to find a new job with a contract for the balance of the 3 years that you still have yet to fulfill. So if you've only worked 6 months or a year, do the math. You need to find a job for a contract for at least the remaining time. Could be more than that. Could be another full 3 years, but you need to at least have that much left. You need to move to another underserved area to fulfill the waiver. And you have to show that there's extenuating circumstances that require the move. I put some examples there, but basically we're looking for something that was unforeseen at the time you obtained the waiver and outside your control. If you get laid off for financial reasons, or you're a hospitalist and the hospital changes providers, that sort of thing, okay, that's not your fault and there's nothing you could do about it. That's quintessential, right? That is like the greatest example of extenuating circumstances. But there are all kinds of factual issues that can come up during the course. There could be disputes with your employer. I just worked with a physician whose practice, was losing their malpractice coverage. That's a pretty big deal. So there could be all kinds of things that come up, in the course of things that require you to change. Importantly, you don't have to apply for a new waiver. Your waiver, you're only ever going to get one waiver, but you do need to move to another state where another location where you can fulfill the intent of that waiver initially. Okay. With this, we're going to leave J1 world for a little bit, and we are going to go to H1B world. I want to make sure that we leave some time to talk about the H's. So, we've been talking a lot about J1s, doctors who do their residency or fellowship in J1 status. There are physicians who complete that same training in H1B status, and some of the things that affect them as they transition to post-training are going to be different than what affects the J1 doctors. So a few key concepts. It's important to know that an employer that sponsors an H1B is required to pay the prevailing wage. What is that? They either have to pay you in line with what they're paying other people in the same position at their institution with like training and education and experience, or they have to pay you at least what other doctors in the area are earning on average. So if you're the only person at that facility in that position, well, you're the actual wage, but they have to pay you in line with what others are earning in the area. A person can only spend 6 years maximum in H1B status unless you reach certain milestones in the green card process, like having an approved I-140, or at least starting that process and having a labor certification or I-140 filed a year before that 6-year maximum. We're not going to spend any time tonight really diving into the specifics of the green card process, but just know if you're doing training on an H-1B and you're going to finish your training, having used 5 years of time, by the time you complete, or even 6, it's really, really important for you to start a job search as early as possible and to connect with employers about their potential willingness to sponsor you for a green card before you even finish your training. I'm actually working on that right now for one doctor. So it's really, really key not to kind of bury your head in the sand and say, oh, I've got plenty of time to deal with that, because you might find yourself at the end of training in an emergency where you're having to beg a prospective employer to, really pull out all the stops to sponsor you right away. An employer must pay all the fees associated with an H-1B petition, legal fees and government fees. Not the same J-1 waivers. There's sort of a, it's a little bit of a gray area, but it's okay, generally speaking, for physicians to pay associated J-1 waivers, though employers are more than welcome to pay, and many do. But for H's, there is no gray area. So employers must pay those fees. They shouldn't ask you to pay it back or to reimburse them or anything like that. And they shouldn't ask you to lay out the fees up front and then be reimbursed. In our office, we will only accept payment for H-1Bs from an employer account. We will not accept it at all from the employee. But the biggest issue and the biggest concept that applies to H-1Bs is the H-1B cap. I was kind of setting that all up, right? Like, let's get through some of the easy stuff and then dive into the H-1B cap. The H-1B cap is an annual nationwide limit on the number of the H-1Bs that can be issued. Unlike J-1 waivers, it is not per state. It is the whole country all at once. There are only 65,000 H's available. There are 20,000 available to those who might have a master's or higher level degree from inside the US. Residency and fellowship are not considered higher level degrees. So if you went to medical school abroad, came here and are an H-1B for residency and fellowship, you're treated just like anybody else who might have a bachelor's degree for purposes of the H-1B cap. The government hasn't come in below those limits. We haven't come in below those limits in terms of the demand for cap H-1Bs since about 2013. So what that means is that every year the cap is oversubscribed. More employers are sponsoring people for these visas than the government can legally support. So the government does a lottery. They call it a random selection. We call it a lottery. It's about the same thing. They do it every March. There's a 2 or 3 week electronic registration period in March, and they conduct the random selection by the end of March. And then if you're picked, we get to file the H-1B petition, which then has a very high likelihood of success. If you're not picked, that's it. It's not a black mark on your record. It's not a denial. It's not a petition denial. It's not a visa denial. It's just you didn't get picked in the lottery. You never even got the chance to file the application. The only start date on that H-1B petition can be October 1st, because that's when the federal fiscal year begins and when the new round of H-1Bs becomes available. So if you're a physician who's going to finish training on June 30th and you take a position that would make you eligible, that would require a cap filing, and you get picked in the cap, that's great. Your residency is potentially going to end on June 30th and your first day of work is going to be October 1st. And then it's important to strategize about how to fill that gap between the two. You can't just stay in the States. It does that H-1B petition doesn't allow it. So you either need to see if maybe your residency program, that facility can extend you for the summer, to go home for the summer. We had doctors take locum positions abroad. So there are different ways to bridge that gap, but it's important to plan ahead for that if you're going to go through the cap. Let's see. I'll get to that green card question in just a minute. There are, though, ways to be exempt from the cap. And we talked about some of them earlier, even though you probably didn't even realize it. Doctors who obtain underserved area J-1 waivers are always exempt from the H-1B cap. So y'all can put your fingers in your ears and be like, blah, 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 blah. None of this applies to me. You don't have to worry about the H-1B cap ever. But doctors on J's who fulfill the home residence requirement or obtain hardship or persecution waivers are not automatically exempt. So this does apply to you if you're planning on doing that. And then, of course, we have our doctors who are training on H's who usually are training with programs that are exempt. And that's how they got the H in the first place. They're usually exempt because they're institutions of higher education or nonprofits that are affiliated with or related to an institution of higher education, or nonprofit or governmental research organizations. Those are the types of institutions that are exempt from the H-1B cap. You can be exempt whether one of those types of institutions sponsors you as the employer, or whether you just work at that institution a majority of the time, even if you're sponsored by a for-profit company. So for example, I do a lot of work with hospitalist staffing companies. They're all for-profit, but a lot of times their physicians work at institutions that are cap exempt, right? They're nonprofit, academically affiliated medical centers. So a lot of times we can still file cap exempt H-1Bs, even though they're a for-profit employer. So it's really important, for H's, you don't need to work in an underserved area to be cap exempt. Underserved areas have nothing to do with H-1B cap exemption at all. What matters is whether you're at one of these kinds of institutions. And the same on the J-1 side. Being at an institution of higher education doesn't matter for J-1s. What matters is whether you're in an underserved area. So the thing that sometimes confuses people is that a lot of J-1 doctors end up in H-1B status because of the waiver rules. But the ultimate, the basic requirements between them do not overlap. They are very, very different, separate requirements. I saw a question in the chat about whether most healthcare organizations require a year or two of employment before supporting the green card process. And that's a great question. So not 2 years. I'm usually seeing anywhere from 3 to 6 months to a year. Occasionally, an employer, one of my employer clients will agree to start the green card process before somebody comes on board when they're in one of those situations, like I mentioned, where they're running out of H time. But most of my clients really want the physician to onboard before they start the green card process. There's so many things that can happen up till that point. They want to make sure that the physician has followed through and that everything has worked out to bring them on board. But once they're there, they're happy to get started pretty quickly, usually within the first year. For a physician who's facing a lengthy green card backlog, the earlier the process starts, the earlier they establish their priority date, which, can dictate how long they're going to be waiting in the backlog. For non-backlogged physicians who are doing J-1 waivers, there's an enforced waiting period of 3 years until they can complete green card processing. And the first few steps are going to take about a year, year and a half. So there's not as much urgency in those cases. I typically recommend for doctors in H-1B status that no matter what the employer's policy is, or where somebody's from, or what their status is, if they're in H-1B status, a green card process should start by the end of a doctor's 4th year in H-1B time. For a non-backlog doctor, it's going to take a couple of years to get through that process, and we want to leave some cushion time there. And for a doctor facing a backlog, obviously their interest, like I said, is getting started as soon as possible, but getting started by at least the end of year 4 allows us enough time to get that person into position to have unlimited H-1B extensions beyond that 6-year limit, without running right up to the deadline. So, I think there are a lot of reasons why different institutions set different policies on sponsorship, but I'm seeing, shorter, some wait times, like I said, 3 to 6 months, max of a year. But beyond that, competitively, it gets a little bit more difficult. Let's see. So we have another question. If you're on a J-1 waiver and in H-1B status and you marry a U.S. citizen, can you apply for a green card through marriage instead of through an employer? And the answer is yes. At the end of the 3 years, you can apply through your spouse. And a lot of my clients do that when they're in that situation. I typically recommend that process start maybe like a couple of months before you finish the 3-year commitment. And then that way you'll be ready to file the green card application right after you finish those 3 years. Keep in mind that you want to stay on that H-1B through the issuance of your green card if possible. you'll get work authorization through the green card process. It's going to take a little while for that to come, and you don't want to leave yourself with a gap in your ability to work. So if you're going to stay on with your J1 waiver employer, that's great, right? They'll just file an extension for you. If you're going to change employers, you definitely want that new employer to file an H-1B transfer for you, so that you can continue working without interruption through the time that your green card comes. And I spent a little bit of time on those questions because we are at the end of the presentation. There's my contact information. I'm happy to stick around for a little bit, for a few more minutes, and answer additional questions if they come in. But you are welcome to contact me via email. I do consultation appointments by phone, and you can make a consultation appointment at our website address at visalaw.com. In addition to myself, attorneys Adam Cohen and Megan Moody also work a great deal with physicians, and so they also can be a good resource for you in our office for a consultation.
If there's any other last minute questions, like she said, go ahead and feel free to put those in the chat box or the Q&A, and we can answer those. I thought you had one come through too.
Me too. And I was like, oh, but you're welcome.
Otherwise, if there's no other questions, I'll still stay logged on for a little bit in case someone's typing something out. But I just wanted to thank everyone for their time tonight and joining this webinar. And thank you, Lisa.
My pleasure. All great.
There was a couple questions about compensation for tonight. There isn't anything for the webinar, but there will be regarding the virtual career fair. Those will go out tomorrow, always within 24 hours after a career fair. Well, if there's no other questions and you guys have her contact information, just in case there is any later on, we'll go ahead and sum up tonight's meeting. All right. Thank you all for your time.
Thanks. Have a good night.
You too. Bye.